Mr. Runway, ready?
We are. Thank you, Mr. Chairman. Mr. Chairman, I understand we will not be offering any rebuttal to the jurisdictional arguments we just heard, and instead this will just be our opening statement on the merits. We'll reserve any comments we have, and we have many about that presentation until our closing arguments on Friday. So we have a second PowerPoint bundle to distribute to you with respect to the merits, and those will be distributed. I think they already have been distributed. Members of the tribunal, you heard a story today about why Rosman lost the excavation area, which is not true. The reason that the claimants lost the excavation area is because they were utterly devoid of the necessary capital to develop the project. The Slovak Republic followed a mandatory statute requiring that the excavation area shall be reassigned if excavation was not commenced within a 3-year period. Here it is undisputed that the claimants never commenced excavation during that period. And that, when I say that period of time, that 3-year period, I mean the 3-year period as confirmed by the Supreme Court. That's January 1st, 2002 to January 1st, 2005. It's undisputed claimants never commenced excavation during that time period, or indeed in the 7 years during which they held their interest. And that by the end of that 3-year period, they were not even remotely close to being able to start excavation. Now, our presentation today is divided into these 6 sections. I'm going to start our presentation by giving you a background just on general mining activities and permits. Some of the facts that were described to you today conflate different permits, and making sure you understand the different permits is important to understanding what really happened here. Could we please go back to the second section is then the 2002 amendment. I'll then, with your leave, Mr. Chairman, turn the floor over to Mr. Alexander, who will talk about what really caused the claimants to lose the excavation area. I will then address the claimants' made-for litigation story, which is what you heard today. I'll also talk about the Slovak court judgments and their implementation by the local Slovak authorities. And finally, Ms. Polakova will conclude with a brief section on public international law. So let's now begin with a little bit of background. It's important that the tribunal understand the different types of activities that occur in mines in Slovakia, and it's very important that you understand the different authorizations that must be obtained before a company can commence mining in Slovakia. Let's first talk about the activities that occur at an excavation site. There are 2 general types of activities. You see them up on the slide. The first is surface construction activities. An example would be the construction of a mining water treatment plant. Now, that's often necessary when water is flowing out of the mine and it needs to be drained into a nearby stream, and to prevent contamination, a water treatment plant is necessary to be constructed. Surface construction activities. The second general type are mining activities, and there are 3 different types of mining activities I list here. First, opening works. Now, opening works make the deposit accessible from the surface. Second, preparation works, which is the development both on the surface and in the deposit after the opening works, such that a specific excavation method can be used. And then third, we have the excavation of the deposit, which is the actual commercial production of the minerals from the deposit. It is this last type, excavation, that the 2002 amendment required to be commenced within 3 years. And later, when we show you the statute, you'll see the word excavation. Indeed, on the next slide, Slovak law confirms that this last activity, excavation, may only be initiated, quote, after completion of the required opening and preparatory works. All right, now with those activities in mind, let's look at the permits. And again, this is important because some of what you were told today conflated these permits. It's very important that you distinguish between them. And I shouldn't call them permits, they're really authorizations that are given by the state. There are three types of authorizations that a mining company must have before it can commence work on a particular site. There is a general mining permit, which is required. That allows the company to carry out specific mining activities, a general mining permit. There's also a requirement that a company obtain assignment of a particular geographic region, a geographic area, an excavation area to perform the specific mining activities authorized under the general mining permit, the first one. Now, these can be granted by an assignment from the local DMO, that's the district mining office, or the higher entity, which is the main mining office, or by way of a contractual transfer from another party that holds the excavation area. And finally, companies also have to secure an authorization for the performance of mining activities specifying and authorizing the detailed manner in which the mining activities shall be performed at that designated area. You were told today that the permit, quote unquote, without being more specific, was extended until 2006. That was not accurate in and of itself, but it was only with regard to the last authorization, the authorization for performance of mining activities. We can go into more detail about what exactly that extension provided for, but it only concerned the third one, and these three authorizations are entirely independent of each other. The reason why that's so important is the 2002 amendment by which and under which the Slovak Republic reassigned the excavation area only pertained to the second. In other words, the Slovak Republic never indicated, explicitly or implicitly, that it was extending the time period under which Rosman had the second, the assignment of a particular geographic area. We call this the excavation area. So when you hear me talk about the reassignment that occurred here, it's always the reassignment of the excavation area. We always must be careful to know which of these three different authorizations we're talking about. And again, the 2002 amendment concerned only the cancellation or the reassignment of that second requirement, the excavation area. So let's turn now to the 2002 amendment. The 2002 amendment was born of good reason. Prior to its enactment, the Slovak Republic had a problem, a systemic problem, with companies who were assigned to that second authorization, those excavation areas, sitting idly on them. Often, companies would not obtain excavation areas for the affirmative use of mining, but for the negative use of preventing other competitors from using those mines. The companies would collect numerous excavation areas throughout the country, develop only some of the sites, and idly hold others, thus preventing their competitors from having access to those sites. So the government undertook a rational response to that problem, and they took it in the public interest. There is legislative history behind the 2002 amendment explaining what Parliament's thinking was behind it. It's called the Rationale Report. That's what in the Slovak Republic legislative history is called. And we have up on this screen the Rationale Report for the government proposal to impose a time period by which excavation, that third activity, had to be commenced. And if it was not commenced within that 3-year period, then that second authorization, the reassignment of the excavation area or its cancellation, would occur. What did the legislative history say was the government's objective? You can read it right on this screen. It says, frequently, in practice, cases occur when the excavation area is assigned to an organization for more years, but the organization does not perform any activities in the excavation area because of various, sometimes even speculative reasons. And it goes on talk about the problem further if the organization did not begin the excavation of the exclusive deposit within 3 years from the reassignment of the excavation area. That proposal was introduced to the Slovak Parliament on 25 July 2001. So now we're talking roughly 5 months before it ultimately took effect. This was not rushed through Parliament. It was a standard piece of legislation trying to respond to a legitimate problem that the country and its citizens were facing. Now, the initial bill, interestingly, made cancellation or reassignment of the excavation area discretionary. The government would have had the option to take the excavation area away or not. It stated, this is the first draft of the law, the DMO, which is the district mining office, that's the first instance mining office, quote, may cancel or reassign the excavation area. But the members of the Slovak Parliament were not satisfied with this proposal because it would have left cancellation or reassignment to the discretion of the local DMO office. And the Parliament therefore adopted a stricter version of the law that made cancellation or transfer mandatory, stating that the mining office will cancel or will assign the excavation area. And members of the tribunal, I am told from my Slovak colleagues that the word will in the Slovak language is the same as the word shall. There is no independent word for it. Now, the Parliament also published a document showing you and the rest of us what its thinking was behind this. And it states here that the reason they changed it from discretionary may to mandatory will or shall is that a failure to meet the time limit for the commencement of excavation must be qualified as a material violation of commitments, and therefore it is necessary to impose by law an obligation, not just a discretion, but an obligation to the mining office. The Slovak Republic, representing the citizens of the country, passed the amended wording of the proposal on 19 December 2001, and the 2002 amendment became effective on 1 January 2002. And the final version of the law is up on the screen, and you'll see it says will assign, no discretion given. And it also refers to that type of activity I described, excavation, not opening works, not preparation, but excavation itself. Now, the 3-year rule imposed by this provision applied to every holder of an excavation area. And it therefore applied, and let me be clear, the Supreme Court, on which claimants rely so heavily, confirmed that it applies to excavation areas acquired both before and after the law was passed. The effective date was January 1, 2002. And as we know from the Supreme Court's decision, consistent with the general laws of the Slovak Republic protecting against retroactive application of legislative changes, the 3-year rule started to run on 1 January 2002. That's what the Supreme Court held. So the 3-year period as held by the Supreme Court that was proper and appropriate was 1 January 2002 to 1 January 2005. You'll see that the DMO had a different interpretation of that at first, but you'll also see it has no impact on Rosman's rights because it didn't commence excavation even in that different 3-year period. Now, as I mentioned, those companies who did not commence excavation yet, it means they had notice that they had until 31 December 2004 to commence excavation. It is undisputed that claimants didn't do so. It is undisputed that they did not come remotely close to doing so. And you will hear that in detail. And because it is undisputed that the claimants did not do so, the Slovak authorities were under a mandatory obligation pursuant to their own legislation to cancel or reassign the excavation area to another entity after that 3-year period, and they did so after that 3-year period in March of 2005. This is a textbook example of a state appropriately applying a mandatory statute. And in fact, the state's application was even-handed. Claimant's investment, in fact, I'll just read this to you. This is a witness statement from Mr. Kukelchik, who is the head of the main mining office at certain relevant points in time in this case. He will be testifying before you later this week, and he stated in his witness statement, quote, in total in 2005, which was the first year that the main mining office, the DMO, could have canceled or reassigned the license, the excavation area of any company, and of course it was the same year where Rosman's excavation area was reassigned. In that year, selection procedures were conducted for approximately 30 excavation areas in which excavation was not commenced in the statutory period or in which excavation was suspended for a period longer than 3 years. This was an even-handed application of the law. No one targeted Rosman. And none of this was a surprise to claimants, contrary to what they told you in this arbitration, and in fact, we heard it again today. Claimants initially stated in their memorial that they were unaware of the statute and that it would be applied to their investment. I've put up the witness statement of Mr. Adyagosh. He stated he was in shock, quote unquote. And on the next slide, we'll see an excerpt from claimant's brief where they stated they were kept in the dark. Somehow Slovakia was hiding its laws from them. So, as we have done so many times in this case, we went to the public record and found out that these statements too were untrue. We found that claimants, and I mean the claimants themselves, as well as Rosman, publicly admitted outside this arbitration that they were well aware of the 2002 amendment and it's relevant to Rosman well before the excavation area was reassigned. In fact, as you will soon see, they were specifically warned by the local DMO office that unless they commenced excavation, the excavation area would be reassigned. Let's look at those documents now. First, Rosman's executive director, Andrei Rozlozhnik, who issued a witness statement in this case and who we look forward to cross-examining later this week, told the press in 2003 that he was aware of the 2002 amendment and that unless Rosman started mining, Rosman would lose the excavation area. And here's where he made the remark. This is in the press. According to executive director of Rosman, this will be definitely decided on the next year because under the amended Mining Act, the firm will have to commence the mining activity. If that is not the case, it will lose the authorization for extraction. Shocked, kept in the dark. Claimants also admitted outside this arbitration that the local DMO office specifically warned them that they would lose the excavation area. Now, you saw that Mr. Adyagosh told you in his witness statement he was in shock when it was reassigned, but in 2004, he gave sworn testimony to the Slovak criminal authorities that Mr. Bafi from the DMO explicitly said to me, and it's right up on your screen, that if we did not start carrying out the works, our exploration rights would be removed as of midnight of the last day of November. And I'll come back to why it's November instead of December. It's not material because they didn't commence excavation and weren't close to doing so anyway. But I'll come back to that. And a tender for the new owner of the exploration rights would be declared. Now, beyond these admissions, which are extraordinary given what you were told in the witness statements and in their briefs, there is, of course, a fundamental rule in Slovakia, like all legal systems, that ignorance of the law is no excuse. Slovak law, in fact, goes further in the mining context, requiring mining companies to designate a responsible representative. For Rosman, it was Mr. Rozlozhnik, who had the obligation, the specific statutory obligation to, quote, not have knowledge of generally binding legal regulations related to, quote, protection and use of mineral deposits. Mr. Rozlozhnik thus had a specific legal duty to be aware of the 2002 amendment, which, as the article showed, he clearly was aware of. Now, this specific knowledge about the 2002 amendment is not surprising. we have provided you evidence in our briefs, and would be happy to cite you back to it, that the 2002 amendment was subject to widespread discussion within the mining community in the Slovak Republic. And indeed, the Slovak Mining Society had conferences and seminars in 2002 and 2003 specifically to help educate mining companies about the 2002 amendment. Despite their knowledge of this 3-year time period, claimants did not come close to actual extraction. Why? Why couldn't they ever reach actual extraction? And for that, I'd ask your permission, Mr. Chairman, to turn the floor over to Mr. Alexander, who will tell you exactly why they were unable to commence excavation during that time period.
Council. Lost my first page already. Sorry, it's getting late. I'm going to now turn, recognizing it's late, but to the fundamental question of, as a practical matter, what caused all of this to happen? And I'm going to go off of my prepared remarks for a second to try to bring it into focus a little bit. Imagine if a company that was engaged in a very expensive enterprise and a very technical enterprise went for almost 7 years without adequate capital. And 2 weeks before the end of its authorized period to begin a particular activity in order to keep its concession, 2 weeks before, the state committed certain irregularities, procedural irregularities under the new statute. If there had never been any capital for this very expensive enterprise, and the evidence of that fact is overwhelming, and what its impact was on this 7-year period, would we ever say with sort of a common sense approach that those procedural irregularities caused them not to be able to excavate a mine? It's nonsensical. But that's the essence of the claim we're facing here. And for that reason, I want to go through what that capital picture was like and how central it was both to their invitation to come and invest and in a variety of promises they made over those years. But that's really what the question of causation is about here. But before I get deep into capital, 2 factors contributed substantially to what led to the failure. One was Rosman's chronic failure to timely submit complete submissions for required approvals and authorizations. We've laid it out in detail in our memorial. The information is summarized in your chart in the slide, and I'm not going to take more time with it at this late hour. Second, we think the evidence already in the record, and what you're going to hear more of, will demonstrate the utter inability of the claimants to provide the necessary capital to bring the mine to production from beginning to end. In fact, if you look closely at their own expert report on what it was estimated to cost, we think, in fact, the evidence is going to show, taking all of their assumptions on figures and estimated capital, that they contributed actually less than 1/10 of the capital that their own expert says was required, less than 1/10, over that almost 7-year horizon. It was actually, I think, 6 years and maybe 9 months, but I'm going to say 7 rounding. Now, a central theme of their claim, and it's in the slide there, from their memorial at 117, is the assertion that in 2000, and this was roughly 2 years after EuroGas first invested, the Gamerska Paloma project had been fully de-risked, and its production of commercially viable quantities of high-quality talc was imminent. In their words, any uncertainties regarding the commercial and financial viability of the reserves had been wiped out by reason of the additional technical reports that had been generated, and that the deposit had been de-risked. Now, you're going to hear that phrase a bit over the next week. It's not a reserve measurement term, it's kind of a colloquial term used in the mining industry, but it means that essentially the risk of the financial investment has been dealt with. And of course, one might reasonably ask, risk as to whom? Well, presumably market participants. All that remained to be done was to open the deposit and start exploitation. But what's remarkable about that statement is it doesn't say a word about capital. Where's the $25 million going to come from? Nor does it address the persistent ways in which the project was chronically impacted by the lack of capital. And the evidence on that is simply overwhelming. The claimants maintain that the Slovak Republic's reassignment on the eve of the expiration of that mandatory 3-year period caused the failure of commercial development. But when you look at the nearly 7 years they were there with the project starved for capital and the trail of promises to provide that capital, you have to ask yourself, could you possibly say that after this long history, procedural irregularities that were corrected by the Supreme Court and complied with by the state, can you possibly say that that caused it? We think not. In fact, the capital requirements were well known from the outset of the project. Indeed, Mr. Robol testified about that in his own witness statement, that he was advised by Dr. Tessner early on that there was need for a strong financial partner. And according to the testimony of Mr. Heidecker, well, let me back up for a second and tell you, there were two major partners when they came in, Dorfner and Tyson. These were substantial mining companies. They had been with the project from the beginning, from 1995. They had done the feasibility study. They had commissioned through their possible financing partner what was called the Geo-Hansa report. Or I'm sorry, Hansa-Geomin report. I reversed it. So those partners were there in place. And Mr. Heidecker was with the project from the very beginning. He was a mining expert involved with the project's development. He'd worked on the feasibility study. And these were the original shareholders into which EuroGas came when it purchased its interest in Rima Moran. Now, they've waived cross-examination of Mr. Heidecker, so I'm going to spend a little more time with it because I think it really is important background. Heidecker was assigned to the project by Tyson and its affiliate and became responsible for its development. He was the top dog. And perhaps, ironically, he rejoined the project in 2011 after he had left it because EuroGas wasn't able to pay him. He left the project because they stopped paying him. Now let me go back to the early days. So after joining the early stages of the project, he worked for 5 years. He worked alongside people who had a lot of mining experience. And he's testified, if we can have that slide, that from the very beginning, it was clear that the project would be technically and financially very demanding, But because of the uncertainty surrounding the project, we did not succeed in finding a financial partner at the time. So Dorfner, and you'll hear it as well from Tyson, there was concern about we need capital. So when Dorfner and Tyson withdrew from the project in 2000, this was only a couple of years after EuroGas and Mr. Robol had joined, and they had announced in 1999 that they were going to withdraw. Mr. Robol, according to Mr. Heidecker's witness statement, asked him if he would continue. And it's understandable, he's lost the two key players, but Heidecker is a possibility, so he came on as the leader. But, as he said in his witness statement, as in your slide, the project soon started to encounter major financial difficulties. when Roseman depleted financial reserves that had been created prior to the entry of EuroGas, GmbH, and Belmont. Now remember, it was Belmont that actually bought out Dorfner and Tyson's affiliate. So what does Heidecker do? He's not being paid for his work. In January 2001, he decided to leave. Now, I want to stop there and pause for a second and talk about chronology, because I think it's so important. Recall that the mandatory 3-year period began on January 1, 2002, the effective date of the law, and expired on January 1, 2005. So we're now talking about events that are transpiring in 1997 through 2000, 2 years before that period even kicks in. So if somebody typically would get assigned the excavation area, they'd have 3 years from the date of that assignment to begin excavation. EuroGas had effectively 3 months short of 7 years. Now, I think it's helpful to think about where we are at that point in time. Mr. Robal enters the project, and how did he do it? According to his own testimony, he did so with a contractual promise to Mr. Chore, whose company, in which he was a significant shareholder, Rima Moran, was the third shareholder in Roseman. And that promise was very straightforward. EuroGas will provide the necessary capital. Nothing ambiguous about it. You'll see that in his testimony. And there it is on the slide, paragraph 20 from his witness statement. Chore said, Rima Moran's unable to provide the financing necessary, and Mr. Robal says, I agreed that we would supply it. But, now we're back to Mr. Heidecker. Remember what he had said a minute ago? By August of 2000, reserves were depleted. Dorfner and Thyssen had left. And soon Heidecker left. So think about how dramatically that picture had changed. The original partners, the mine experts, the people who developed the feasibility study, who'd commissioned all the significant work, who were working to try to find financing, they were gone. Heidecker was gone. Belmont came in for about a year and a month, and then it entered into the share purchase agreement to sell to EuroGas. So what was left? EuroGas. Only 2 companies for that year and a month, and then EuroGas. Now remember the relationship between these 2 companies. Very important. You've already gotten a sense of it from what you've heard today. They acknowledged they were related parties for certain reporting purposes in SEC filings, and that their transaction could be described as other than arm's length in the context of some relationships. They shared a common director for a period, Mr. Agigos. But both lacked substantial capital, let alone the kind of capital we're talking about here. Now, so they need to go to the capital markets. They need to go to lenders, potential farm-out participants, potential purchasers of portions of the interest in the company. But with the filing of and remember, they're both public companies. With the filing of their 2000 year-end financial statements for the prior year, so those would have been filed, early 2001. So right about the same time that the partners are pulling out, Heidecker's gone, financial problems are starting to commence. You read those statements and you can see plainly just how close they were to financial collapse. It would have been clear to anybody who read those public filings. Every potential capital market participant's going to do due diligence. What's the first thing they're going to do? Look at the public records. Look at their SEC filings. They could see the operators of this project were without any meaningful capital resources. Now, just think about it practically. if you're being asked to invest or loan substantial dollars on a project that's gonna cost 25 million euros to develop, is that gonna make anybody comfortable? Well, in the case of EuroGas, and this is in Exhibit R143, and I apologize, I don't have a slide for you on it. I somehow misplaced it earlier today. They could see in R143, which is what's called under American securities laws an S1. It's what's called a registration statement. It's filed when you're seeking to issue new stock as a public company. And it's required to be filed with the U.S. Securities and Exchange Commission, open to the public. Filed in support of EuroGas's efforts to issue more stock, R143. As to EuroGas, and I say I don't say this to offer any embarrassment to anyone here, but I think it's important to recognize that this was EuroGas's self-reporting. This is its description of its own affairs. That they were defending serious litigation, had been under SEC investigation since August 1995, and had produced voluminous documents as part of that investigation, that its auditors had also been called upon to produce documentary evidence, and that Mr. Robal, listed as a director, an important person, had been convicted by a German court in other matters relating to a bankruptcy in Germany, in matters bearing a remarkable resemblance to what was about to happen here with EuroGas's subsidiary, Roseman. I mean, it's stunning when you look at the description in that report. The parallels between the matters at issue and the matter that led to that conviction and the state of financials here are important. Think about the investors or capital market participants or lenders. Robal's conviction was for a failure to capitalize a subsidiary, or alternatively, in order to protect creditors, to put it into bankruptcy. Final point, they would read, as to EuroGas's financial affairs, again, a legally required document filed annually in the annual 10-K report, would read that EuroGas had virtually no revenue, had been loss-making for years, and that its accumulated deficits were very large and growing every year because it was losing money year after year after year. As the tribunal may recall, we engaged PwC's Sershar Qureshi, who they passed on cross-examining him, so I just want to touch on this because I think it's very important to this issue we're discussing. We engaged him to conduct an analysis of whether claimants were able to secure financing to complete the project. Fundamental question. If Roseman's rights to the excavation area had not been allowed to lapse by reason of the running of the 3-year period, could they have ever gotten financing? Mr. Qureshi's report, based again largely on publicly available information, focuses primarily on EuroGas because he notes in his report that Belmont, by its own admission, reassessed after it had been in the project for a year and a month, concluded that the capital requirements were substantially larger than they expected they would be, and he made a determination that he had to sell. So that's when I say there it was, EuroGas all alone. So Mr. Qureshi looks at EuroGas. As for what he looked at, summarizing the reports from the period, and it's on your slide, I hope, from 1997 through 2004, the relevant period, through the final year of the period to initiate excavation of the deposit, you have to ask, how did EuroGas survive outside of bankruptcy as long as it did? From paragraph 62 of his report, he notes the following: that EuroGas had no operational revenues, had increasing accumulated losses, experienced a sharp decrease in its share price, and self-reported significant doubts as to its ability to continue as a going concern. That's EuroGas to the investing public. So there's an introduction on the lack of capital resources. I want to turn now quickly to some of the other testimony that I think it's important to have as we enter into this phase of the hearing. First, if we have the slide for Mr. Agigos, after he purchased the 57% in Roseman, which I said a minute ago, he further investigated the project and came to the conclusion that it would need to raise greater sums than he had anticipated to prepare the deposit for its commercial development. So he contemplated in early 2001 selling his 57% interest. Now, and he ultimately sold, of course, as the tribunal already knows, to EuroGas. And he did so in exchange, among other things, for the promise and contractual commitment for EuroGas to, quote, arrange the necessary financing to place the Gamerska-Paloma talc deposit into commercial production with 1 year from the date of execution. Execution was 27 March 2001, so 1 year later takes you to 27 March 2002. That's only 3 months into the mandatory period. So at the time that deal was struck, those parties obviously agreed it could be done in a year. And more importantly, EuroGas agreed they would do it within a year because they would fund the capital. That was the commitment. Now, remember that chronology I set out a little bit ago? If you look at where we are in that chronology, as I say, if EuroGas had provided the necessary financing, they would have been in production in March 2002 with a lot of headroom on that 3-year period. 33 months, 30 months of extra time. But it didn't happen. That was the promise. Production within a year, but nothing close to that happened. So then I turn to Mr. Chore, who's explained in great detail. I'm going to move through these slides pretty quickly. I just want to point out how dramatic this lack of capital was impacting the project. He's a partner, of course, in Rima Moran alongside EuroGas. Miners were threatening with a strike because they weren't being paid. Payments from Roseman were always late. We didn't have money to pay for the works at the deposit. We owed our suppliers, and we were under a threat of bankruptcy. We tried to get financing from a bank, but couldn't. Then he says insufficient financing in the summer of 2001. Now that, of course, was still before the inception of the mandatory 3-year period. Led to an open dispute between Rima Moran and Roseman, as a result of which Rima Moran discontinued works at the deposit several times. Now, again, some of these names can get a little confusing sometimes, but remember the relationship here. EuroGas itself is the majority shareholder of Rima Moran during this entire period. It's the majority shareholder. And it's not funding its own contractor to keep the miners from striking or to keep the works from being discontinued. So after 5 months of further delay, on 28 November 2001, the works were formally suspended, and that was notified to DMO. How am I on time? I'm going to check my time here if I may.
So you have 24 minutes left
Okay.
by my watch.
And how much does she need? Okay. I'm going to have to pick it up here. I've I want to point out one other date, though. The notice of suspension stated as the estimated date of renewal of works, 1 May 2002. So the job is shut down, it's suspended, Rima Moran is not getting paid, they go off the job. But if the date could be hit for the resumption of works, which is estimated by Roseman, think how much headroom they still have. They can come back 6 months into the mandatory period, resume the work, and remember, EuroGas said we can do it in a year. They'd said that about a year prior to that, because it was ready to go. But still, no capital materialized. No significant capital materialized, despite efforts to borrow funds and sell an interest in the project. Recall that these events are occurring 2 years after the point in time when EuroGas had said in its memorial that it was de-risked and ready to go. And this was happening about a year after EuroGas promised to provide the capital to get it done within a year. So EuroGas had breached not only its promises to Rima Moran to provide the necessary financing for the development of the project, it had breached its promise to Belmont, quote, to arrange the necessary financing to place the project into production by 27 March 2002. And though EuroGas had tried to sell, according to Mr. Agagos, that option had also failed. If you look at his testimony at paragraph 29 in the slide, he says it very simply. EuroGas was, however, unable to sell its interest in Roseman and did not provide any financing. So the deficits continue to mount for both companies. The major financial difficulties that Heidegger had described had reached utter financial collapse. And then what happened? EuroGas suffered in Texas, and then in Utah, an enormous judgment for fraud and conspiracy, and was found to have given false testimony to a U.S. bankruptcy court in a public document. Soon thereafter, involuntary petition for bankruptcy, May of 2004, and an order for relief in October of 2004. So with no realistic prospects to raise the necessary capital, broken contractual commitments, bankruptcy, EuroGas began what we submit the evidence this week will show was another shell game reminiscent of the conduct in which it had been engaged and which became the subject of the fraud and conspiracy judgment against it. We believe the fair conclusion is going to be that this was reminiscent of the same kind of approach that was the subject of that fraud conspiracy judgment. All of the events I've described so far occurred prior to anything happening with respect to the reassignment of that excavation area. All of this capital crisis occurred before anything to do with the reassignment of that excavation area. So what happened then after EuroGas is in bankruptcy? I'm going to move through this quickly. We've touched on some of it already. Number one, testimony by EuroGas's CFO that EuroGas did not own the interest in the Slovak talc mines and the claim related thereto. The outright flaunting of the U.S. bankruptcy court's order to file schedules, to disclose the interests. Flaunted it. A secret incorporation of a new and separate legal entity, a sham and secret merger agreement, executed after the conclusion of the bankruptcy with purported retroactive effect to the period of the bankruptcy. The failure to disclose this obviously material information in any SEC filing, Never told the investing public that there was a EuroGas 1 and a EuroGas 2. Never told the investing public that EuroGas 1 had been dissolved. Never told the Austrian Commercial Register any of those facts. And then the web of asset transfers you've heard about in the jurisdictional section in an effort, respectfully, to manufacture jurisdiction before this tribunal. And fundamentally, it started with the initial misrepresentation to this tribunal of the identity of the entity. Fundamentally, what caused this project to fail? A lack of capital. It was a $25 million project. They brought a tenth of that to it. Those failures occurred long before any of these issues arose at the tail end of the project. They didn't change the cause of the failure of this project. Thank you very much. I turn the floor to Mr. Hambley.
And Mr. Chairman, let me just pick up then on a point we have tried to emphasize in our papers, which is something we'd like you to keep in mind for the rest of these hearings, and that is the issue of causation. I'm going to come to the rest of the alleged actions in a moment, but as you will see just from reading any of the Supreme Court decisions that were handed down, those Supreme Court decisions never found that excavation was actually commenced. Indeed, as I mentioned, it wasn't even remotely close to being commenced. And the claimants don't dispute that in this arbitration. And for that reason, nothing that could have occurred at the end of, and certainly well after, the 3-year period could have caused any harm to Rosman, since it had already failed to fulfill the requirement to keep the excavation area. And I want to emphasize that Rosman was precluded by law as the entity from whom the excavation area was being reassigned from participating in the new tender. That is, it had no legal right to get the excavation area back. And so they could not have suffered any damage from any of the events that occurred after or even at the end of the 3-year period. Regardless of the state acts that later occurred, it still would have been required to relinquish its excavation area under the 2002 amendment. Now, you heard a very different story from claimants today about why they lost the excavation area. I'd like to address some of those comments now. The claimants try to create the impression that the Slovak authorities had told Rosman that they would not lose the investment, whether by extending what, as I've already explained to you, is a different permit, totally independent, or the other act that they cite to is a inspection from Mr. Bafi to the site on 8 December 2004, which was 1 month before the end of the 3-year period. Just want you to understand that the reason for that inspection is that a month earlier, on 8 November, Rosman informed the DMO that it intended to resume work at the site. Now, under law, it is required that the local DMO personnel come to the site and do an inspection. You were given the impression today that that inspection somehow verified that the excavation area would not be reassigned. That was not the purpose of the inspection at all. This is a routine inspection that is done when the DMO receives notice that there will be a resumption of works. And the main purpose of the inspection, indeed the purpose of the inspection, is to verify whether the contemporaneous on-site activities are being carried out in accordance with Slovak law, and in particular, safety regulations. So upon receiving the announcement on 8 December, Mr. Bafi from the DMO conducted a routine inspection to simply make sure that nothing that was going on at the site violated Slovak law. And of course, nothing did. He observed that Rosman was performing surface works and concluded that none of the surface work activities were carried out in a way that would run afoul of local regulations, especially the safety standards. That's the beginning and the end of the story. It was a routine inspection. The inspection had nothing to do with Rosman having commenced excavation during the 3-year period or whether the 2002 amendment would be applied to Rosman. And that stands to reason because Mr. Bafi did not have the authority to ignore the 2002 amendment, which was mandatory law. It was only to ensure there was no violations of Slovak law. And just so you can see it for yourself, on slide 46, this is from Mr. Boffey's report. This is completely unremarkable. It's a routine inspection. Today's inspection, no facts were discovered indicating a breach of legal regulations in force. That's the beginning and the end of the story. Now, they also have portrayed to you that the state had pre-decided to reassign the license. And they really cite to two different arguments. First, they cite and build a substantial amount of their case on the fact that the notice of initiation of the tender procedure for the assignment of the excavation area was published 2 days early. Now remember, they were not even close to being able to commence excavation. Everyone who knew anything about that excavation area knew it was impossible for them to start at this point in time. Why did they post it 2 days early? You'll recall earlier that the DMO, Mr. Boffey, had warned that they might lose the site as early as November. Now, the reason that he said that, and the reason that they posted the note when they did, is that the local DMO office thought that the statute applied starting at an earlier period of time. It was a good faith interpretation of the statute. They thought it commenced on 1 October 2001 rather than 1 January 2002. Now, why that day, 1 October? That was the day when Rosbin announced it was suspending work at the site. And so the DMO thought that the 3-year period ended on October 2004. That was a good faith understanding of a brand new law. And so when they published this notice on 30th of December, it was after the 3-year period as the DMO understood it. Now, with the benefit of hindsight, we know the Supreme Court disagreed and said, no, the period started 2 months later. But that makes no difference because Rosman still was not able to commence excavation and was not close to doing so during that 3-year period that ended on 1 January 2005. And so this miscalculation by the DMO, this incorrect interpretation, had no consequences for Rosman because Rosman had not commenced excavation in that time either. But that interpretation that the DMO had explains why they published 2 days early. There was nothing nefarious in it. They had a different interpretation of the time period, and it turned out to be irrelevant to Rosman in any event. In any event, the selection procedure to assign the excavation area commences only upon the first act of the DMO toward Rosman, vis-a-vis Rosman. And that notification of the assignment of the excavation area was dated 3 January 2005, after the 3-year period, even as confirmed by the Supreme Court. And so the administrative proceeding started only after the expiry of the 3-year period. Members of the tribunal, are claimants really staking an investment treaty arbitration case because a notice was posted 2 days early, when any reasonable observer already knew that the tender would happen because Rosman was not even remotely close to being able to commence excavation? Now, the second argument is that the Slovak Republic engaged in negotiations with third parties regarding the reassignment of the excavation area before the end of the 3-year period. Now, I want to be clear, the Slovak Republic did not negotiate anything. The documents that the claimants rely upon merely show that there was an interested investor, Mondo, represented by Mr. Keller, who had an interest in cooperating with Mr. Chore if there was going to be an upcoming tender, and they requested a meeting with the Minister of Economy. He's the minister in charge of mining. The minister agreed to have the meeting. That's what the documents show. Nothing else. And as Mr. Chore explains in his witness statement, at that meeting, well, he first notes, quote, "It is not uncommon for investors to want to meet with the relevant minister to discuss the relevant ministry's policies and plans for the future before making significant investments. These meetings are ordinary course. It's what you would expect if you are an investor walking into a country and expecting to invest millions of dollars." In addition, the allegations surrounding these documents are incorrect. The meeting was not at the Talk Deposit. The Minister of Economy never met with Mr. Keller or anyone else from Mondo at that site. Instead, the meeting took place in Košice, the second largest city in Slovakia, some 75 kilometers away from the deposit, and Mr. Chore, in his witness statement, states The minister at that meeting made clear that any interested party in the deposit would have to participate in an open tender selection procedure and no one would be given preferential treatment. There is absolutely no evidence that the minister promised anything to anyone. And Mondo didn't even win the tender. So it's unclear what claimants are even trying to prove with these documents. Members of the tribunal, there is nothing before you that suggests in any way, shape, or form that corruption was involved. Frankly, we are troubled by how, on such a meager, indeed non-existent record, the claimants would throw out such a sensationalistic and irresponsible allegation. Now, as noted above, it was public knowledge that the proceedings on cancellation or reassignment would be initiated on this 3-year lapse because they weren't even close to starting excavation. As we noted in our papers, and as I explained to you at the beginning, there are opening works, preparation, and then excavation. For the opening works, they had only completed 7% of just the opening works. That means they were 93% of the way from completing opening, much less preparation, much less actual excavation. Given how much work would have to be done to start excavation, it was impossible for Rosman to start it anytime soon, and naturally, other industry actors began inquiring about the area. That is hardly surprising or unusual. I'm going to conclude now with the court decisions. Now, I've already told you there's an enormous causation problem with claimant's case, because anything that happened after that 3-year period can't have caused any harm to Rosman.
Are we also going to hear from Ms. Polakova?
I had hoped so, but unfortunately, I think we're a bit short on time.
How long?
You have 7 minutes left.
As good as Ms. Polakova's presentation is, given how much the Supreme Court decisions have been discussed, I do feel like those facts are important and facts that I need to address. So we would ask for perhaps a little leniency, but if that is not possible, perhaps we could do it at our closing argument.
10 minutes would not be a problem.
Okay, thank you. There were 3 Supreme Court decisions that the claimants discussed, but the last one did not involve the excavation area. It involved the general mining permit. Again, you'll recall there are the different authorizations. And because it doesn't relate to the excavation area, and we have never received a full explanation for how this could have caused any damage to Rosman, I'm not going to focus on that, just in the interest of time. We've dealt with it in our papers. I'm going to focus on the 2 Supreme Court decisions, the first 2 that did relate to the excavation area. Both of those decisions required that the district mining office run again, reconduct the reassignment proceeding. But this is the key fact that you have been continuously misled about. Neither of those decisions ever required the DMO to give the license back to Rosman for future use, or ever concluded that Rosman had in fact commenced excavations. They simply told the DMO that it needed to rerun the reassignment proceeding because of procedural deficiencies. The first decision was about a procedural issue. Now, the 2002 amendment required, we know, reassignment after 3 years. It did not establish the detailed procedures by which that reassignment was to occur. And because of the absence of any kind of detailed statutory guidance, the DMO was sailing on uncharted waters, applying a new statute without the benefit of precedent, without legislative guidance, or any other authority that would guide them on how to do the procedure. Now, ultimately, the way the DMO conducted the procedure was to issue a simple notice to Rosman in early 2005 about the reassignment area. It did so because it was a mandatory statute. It conducted an open tender, and it ultimately reassigned it to a company called Economy Agency. Mr. Chore was involved, but that's not surprising because Mr. Chore had almost as much knowledge about that mine as anyone. It's not at all surprising he would put in the most competitive bid given his intimate knowledge of the mine. Now, Rosman challenged that decision, alleging that the procedure by which the reassignment, the excavation area was reassigned was faulty in 2 respects. First, it argued that a full administrative proceeding was required rather than a simple notice. And second, Rosman said that Rosman should have been a party to the proceeding, even though it had no legal right to get it back and could not get it back under the law. It was appealed all the way up to the Supreme Court, and the Supreme Court agreed with Rosman. It went down to the DMO, and what did the DMO do? We have been told over and over again the DMO ignored the Supreme Court decision. The DMO conducted a full administrative proceeding, that was holding number one, and it allowed Rosman to be a party. That was holding number two. It did exactly what the Supreme Court said it should do. The Supreme Court did not opine on the license going back to Rosman. Now, Rosman appeals that again. It goes all the way up to the Supreme Court, and it raises a number of arguments that were not raised in the first appeal. And I could list them, but I'm very conscious of my time. There are 5 different arguments, we've set them forth in our memorial, that they raised in that appeal. Now, why do I mention that? Because if Rosman had raised these arguments in the first appeal, then the second appeal wouldn't have been necessary at all. Years of litigation would have been saved. Rosman engaged in piecemeal litigation, and in so doing was solely responsible for this second appeal. Now, the Supreme Court ultimately found some of these arguments, but not all of them, meritorious. One of them was that the 3-year period was not October 2001 to October 2004, but January 2002 to January 2005. That was one of them, the retroactive point. And it also instructed the DMO to undertake a more fulsome analysis, something it had never told the DMO to do before because Rosman hadn't raised it in the first appeal. A more fulsome analysis of the activities on the site. On remand, the DMO again followed the Supreme Court's decision faithfully. It did a thorough investigation of Rosman's activities on the site. The DMO inquired about the reasons for Rosman's failure to excavate and considered Rosman's financial contributions and commitments to the site. And on that basis, it issued a decision on March 30th, 2012. Here's what it found. Number one, and this is the DMO applying the second Supreme Court decision that you've heard so much about. In a very detailed decision, number one, the DMO concludes, between 1 January 2002 and 1 January 2005, Rosman did not excavate at the site and failed to perform any of the DMO-approved activities that were necessary to lead to excavation. Number two, Rosman had performed little work at the site. For example, and this was the point I raised before, out of 1,300 meters of decline, that's the opening works, that needed to be built, Rosman had only built 93, 7% of just opening works, not preparation and not excavation. The opening works had to be completed first. Number three, given Rosman's failure to advance on works at the site and the site's flooding, it could not comply with a pre-approved plan. In other words, and I won't go into detail, but Rosman was so far behind schedule that it couldn't commence excavation before the 3-year period in any event. Number four, Rosman had not demonstrated that it had sufficient financial resources, recall Mr. Alexander's discussion, or the ability to secure funding necessary to commence excavation. Number five, Rosman's failure to commence excavation was its own responsibility and did not result from, number one, the geological characteristics of the mine, two, the technical conditions of the project, or three, interference from the Slovak authorities. There was no interference from the Slovak authorities, which prevented them from being able to commence excavation. And based on these findings, the DMO concluded that Rosman's activities at the site were speculative, and that instead of concentrating on developing the mine and excavating the resource, their apparent goal was to delay work, limit its capital investment in the mine until it found a senior mining company interested in buying Rosman out of the project, which we know it could not do. The DMO then also applied a public interest analysis raised by the Supreme Court and reasoned under the mining regulations in effect the public interest was best served by having a rational use of the country's natural resources. Based on these findings, the DMO confirmed its earlier decision and assigned the excavation area to VSK Mining, which at that time was the legal successor to an economic agency. Now, Rosman then appealed to the DMO again, which denied Rosman's appeal. And importantly, members of the tribunal, and now I come to the end, Rosman did not exercise its right to challenge the MMO's decision before the courts. If Rosman believed that second DMO decision, detailed decision that followed faithfully every single thing the Supreme Court told it to do, if it thought that that was not in accordance with the second Supreme Court decision, then it could have submitted a claim and appealed to the Supreme Court. And if the reassignment was contrary to the Supreme Court's decision, then the Supreme Court would have certainly reversed it. But Rosman chose not to do so, and the fact that it chose not to do so is very telling. Having not given the Supreme Court an opportunity to review whether the DMO reached a wrong conclusion or didn't follow its instruction, how can they complain about it now before an international tribunal? Any suggestion that Rosman did not turn to the courts because it lost faith in the courts is disingenuous, because Rosman has always been successful before the Supreme Court, showing that the Slovak Republic is not at all adverse to the claimant's investment. And nor can claimants plausibly argue that Rosman was discouraged after 8 long years of court proceedings, because as I showed you, Rosman itself was entirely responsible for that second appeal. If it had just raised those arguments in the first appeal, there would have been one and only appeal. With the benefit of the Supreme Court's decisions on this brand new legislation, the DMO rectified all the procedural deficiencies identified by the Supreme Court and always acted in compliance with its instructions. And of course, none of it could have harmed claimant's investment anyway, because it never commenced excavation during the 3-year period. Members of the tribunal, I don't know if there is time left for Mr. Lokiova's, Ms. Polikova's change in last name recently.
Certainly not left in the time allotted.
As you wish.
Rely on your memorials.
Thank you. And I think we can probably find a place for it in the closing arguments on Friday.
Yes, I think that's necessary, maybe not for legal reasons, but for human reasons.
That was my thought as well.
Just a question. Back to slide 6, please.
Yes.
The third authorization, say.
Yes.
Authorization for performance of mining activities. How is it distinguished from general mining permit and assignment of a particular geographic area? Can you explain?
Yes. So, and I'm happy to defer to some more local, some counsel who may be more familiar with the local regulations. But my understanding is a general mining permit is exactly as it says, very general in nature. This is an overarching permit that a mining company must have before it can engage in this activity anywhere in the country. Obviously, the assignment of the particular geographic area is limited to the particular geographic area. My understanding of the authorization for the performance of mining activities is that it is a specific, detailed authorization for the particular plan that will be
In a
executed.
specific area?
Is that correct? As I understand it, that's correct, yes.
So it's more
But it is not the assignment of the particular geographic area. There is a sharp distinction between 2 and 3, and they operate independently of each other.
Thank you. Well, thank you. What's the plan for tomorrow? You have 3 witnesses to cross-examine, Mr. Agiagos, Mr. Raubal, and Mr. Rozlosny.
Correct.
Will that take the whole day?
I would be surprised if we finished all 3 tomorrow.
Okay. So we start, I think, with Mr. Agiagos in the absence of Mr. Raubal in the room.
Yes, indeed.
Anything before we leave?
binding, very rough indication of how much time you would have with the first witness, so that at least Mr. Robel can...
I would think it would be somewhere, much obviously depends on the witness, but I would suspect it would not be any less than 3 hours.
So we'll plan for Mr. Robel to be there in the afternoon, I guess.
I think that's fair.
Okay.
Because we start at 9.
Yeah.
Yes.
Yeah.
Okay. Well, thank you, and see you tomorrow.
Thank you.